Attorney General Pam Bondi and Donald Trump's cover-up continues. They were so intimidated by special counsel Jack Smith's testimony before Congress. They first refused to allow Jack Smith to discuss volume 2 of his report, which involved Donald Trump taking documents, classified information, and hiding it at Mar-a-Lago and then obstructing justice. They refused to allow special counsel Jack Smith to testify about that at the congressional hearing. You see, Judge Eileen Cannon has kept under seal all of the filings relating to volume 2 and relating to the Mar-a-Lago document case, which she was presiding over, even though she dismissed that case longer than a year ago, 2 years ago at this point. She still claims jurisdiction over the case, and she says, I am not going to allow volume 2 or anything about that case to be released until I hear further briefing from the Department of Justice. Except, you see, Judge Eileen Cannon did nothing for over a year. And then finally, the 11th Circuit Court of Appeals is like, you realize you're the judge on this case still, so you have to make a ruling about volume 2 and about when it's going to be released, to which Judge Eileen Cannon responded by doing a briefing schedule and said, just get back to me sometime in like late January or February. And, you know, as we predicted here on the MeidasTouch network, what Pam Bondi was going to do is she was going to, have the DOJ do a long briefing schedule. Then she would sit on it for a while, and then she would come up with ways to further delay. But it was going to be interesting to see what the Department of Justice says about volume 2, the Mar-a-Lago document case, because people like Pam Bondi and others in the regime, they go on Fox all of the time, and Donald Trump, recently posting about Jack Smith, they attack him. Oh, he lied about this. He lied about that. He needs to be prosecuted this. And special counsel Jack Smith is like, I will talk to the House, to the Senate, any committee you want to bring me in front of. I'm good. I want to talk about my investigation. Obviously, if it's highly sensitive, classified information, I'm not going to talk about that, but I should be able to talk about the case and my role as a special counsel. The special counsel statutes say that the special counsel is essentially supposed to testify before Congress, and there's never been a situation where a special counsel has been from appointed by either political party has ever been prevented from testifying about their investigation. And that's precisely what happened. I mean, we all know special counsel Jack Smith testified this past week in Congress, but all he could testify about was the January 6th case and not the Mar-a-Lago case. The DOJ said, based on what Judge Cannon has ruled, we, the DOJ, will basically prosecute you, Jack Smith. We'll throw you in prison if you even talk about anything that had not been public about the Mar-a-Lago document case, and so Jack Smith was like, well, you want to provide me guidance of like what that means? No, we don't want to provide you guidance. Good luck. You say something about the Mar-a-Lago case that we believe is under seal, we'll prosecute you, Jack Smith. And so that was put on the record as well. I'll show you that in a moment. But now we know what the DOJ's plan was all along, and they've made the argument here before Judge Cannon that everything in volume 2, again, this is all of Jack Smith's report on the Mar-a-Lago document case about Donald Trump taking these classified documents, and everything that was uncovered during the investigation constitutes, quote, deliberative communications, internal deliberative communications, and thus are not allowed to be produced ever. That volume 2 may never be released ever is the DOJ's plan. So if you're keeping tabs, yes, they're covering up a child sex trafficking ring, not releasing the Epstein files, only releasing 1% of documents. Yes, they're now covering up volume 2. Yes, the administration that says they're the most transparent ever. Let me just read for you their words so you can see for yourself. United States response to December 22nd, 2025 order. Notice how Judge Cannon gave him like over a month to basically respond to her order after she sat on volume 2 for years at this point, until the 11th Circuit said, Judge Cannon, do something. So it says, the United States respectively submits this response to the court's December 22nd order, in which the court announced that its order enjoining the release of volume 2, final status report, she had questions about it. The United States agrees with the former defendants in this case that volume 2 should not be released outside of the Department of Justice. As this court correctly determined in its July 5th dismissal order, Jack Smith's investigation was unlawful from its inception. Smith not only weaponized the Department of Justice against the leading presidential candidate in pursuit of an anti-democratic end, but he did so without any legal authority and while targeting constitutionally protected activity. Apparently, you have a constitutional right to steal classified information, according to the DOJ. Put simply, Smith's tenure was marked by illegality and impropriety. In addition to Attorney General's unconstitutional appointment of Smith as special counsel, Attorney General Pam Bondi has determined that Volume 2 is an internal deliberative communication that is privileged and confidential and should not be released outside of the Department of Justice. And then they cite some law. They say, explaining that in the absence of an order barring the release, the decision release of Volume 2 outside the DOJ should rest with the sound discretion of the Attorney General. The Department of Justice further acknowledges that it cannot provide the court with additional assurances regarding the scope and adequacy of Smith's proposed redactions of Rule 6E materials from Volume 2. As this court previously observed, current department counsel has only secondhand information about the process by which Smith made redactions for Rule 6E. Current department counsel was not involved with Smith's investigation because Donald Trump fired everybody regarding Smith's investigation. And when the DOJ says we agree with the defendant's position, they're saying they agree with Donald Trump, who is a defendant in the case, who said to Judge Cannon, don't release these files. Now Trump's personal law firm, the DOJ, says don't release the files. Just a reminder of what went down at the hearing with Jack Smith. Here's Jamie Raskin, Congress member and ranking member for the Democrats. Here's how he described Volume 2. Let's watch it.
You've done and nothing that I've done. Jack Smith has not been able to answer the vast majority of questions about what's in Volume 2 of his special counsel report relating to the stolen documents. Now, it's been said that the judicial order that Eileen Cannon imposed will be lifted in February. And so I guess my point of order is, do we intend to bring him back so he can answer questions about Volume 2 and about the stolen documents case?
We'll take it under advisement.
Okay. Well, then
just see what the court decides to do, frankly.
I got you. Well, then in that event, I've got the signatures of every member on our side who are writing to notify you of our intent to call him to testify in continuation of this hearing to answer all of the unanswered questions about the second half of his work.
That will certainly factor in tremendously when we make our decision.
Okay, because we have a right on the minority day to have a witness, and we will exercise that right.
You're going to call him back again?
Yes.
Wow. Okay.
So
we'll see.
Yeah, okay. I'm citing Rule 11, Clause 2J.
We look forward to seeing the letter, and we'll find out. We'll take it all under advisement, as we said. That concludes today's hearing. We thank the witness for appearing.
I want to bring in Harry Litman of the Talking Feds YouTube channel, Talking Feds podcast, Talking Feds Substack. Again, Harry, apologize for that long opening right there. But what I wanted to share was what specifically in the words of the DOJ and the setup right here, right? You have Jim Jordan, the MAGA Republican who's not a licensed lawyer, who chairs the Judiciary Committee, which always fascinates me that that's who they pick to chair the Judiciary Committee. We'll see what the judge does. The DOJ swoops in. The DOJ says, Judge, these are deliberative communications. They're privileged. You can't produce them at all. Judge Cannon, who Trump appointed. This is the height of corruption. This is what you'd expect to see in Russia, Harry. Am I right?
100%, Bannon. And notice what we're talking about, right? Having foiled through the vagaries of election a case that anyone who's looked at thinks is completely righteous. Really, his conduct is indefensible. The January 6th crimes alleged were more serious, grave as against the Republic, but this is an open and shut case that would maybe well have been tried, notwithstanding the ticking clock, but for Eileen Cannon. Having defeated that, they are trying now, and I think in contrast to every single independent counsel investigation of which I'm aware, to just smother it from history. What is on on one side, the clear, important right of the public to know the possible criminal charges of the then former president. And what's on this side? You know, everybody is arrayed personally and politically against the truth coming out. But just to review the bidding, by the way, how about that Jim Jordan? Oh, we'll take that under advisement with that shit-eating grin, meaning like, screw you, Jamie Raskin. But I just want to put a finer point on what you said, Ben, because here's what happened. The case ended. It was dismissed as against Trump, but there was this extant order under Rule 6. You got to keep grand jury material safe while a case is pending. And she just froze it for a year, has done nothing. Finally, as you say, she got spurred to do it. And what did she do then? Invited Donald Trump, who's no longer a party, and the DOJ is a party. Can you get your mind around this? What are they doing here? They're the prosecutors. They're the one who brought the case. That's the reason that they are parties to this case. And then Nauda and De Oliveira, the potential defendants, and that's going nowhere. So it's just a really crass and completely transparent account from the same people. Donald Trump yesterday at Davos was protesting his innocence of one of the charges, and they again and again, the official position of the Department of Justice before Judge Cannon was that this is completely illegitimate and the whole thing was, total ultra vires. That's like a bad joke for anyone who knows the case. They may be referring to the complete crazy ass ruling by Eileen Cannon saying there was something flawed about Smith's holding, but about Smith's appointment. But nobody who's looked at has been able to challenge the merits of the case at all. Now, so they come in and basically say the people of the United States should never know the facts of what happened. As you say, at his previous testimony, DOJ, how do you like this, said, remember, if you say a word about this, we're going to prosecute you. And they're looking to prosecute him no matter what. And he said, okay, give me guidance what not to say. Sorry, you're on your own. These are just sheer, antagonists looking to, he and Jim Jordan and Eileen Cannon, they're all arrayed against him. I just want to note, the so-called deliberative process privilege, and that's what they're saying, unlike any other special counsel report ever, somehow this is just about the deliberative process, presumably between Smith and the rest of the department, Merrick Garland. It is, like most of these privileges, a qualified privilege, meaning it gives ground when there is need on the other side. Now, Eileen Cannon is never going to find need on the other side. But then, there's a standing issue, right? Because we're in a collusive situation now where the prosecution has become the defense, and who is going to appeal whatever order she enters to the 11th Circuit. But if and when she does, the fair legal analysis here, in my view, is just not even remotely difficult. You have, on the one hand, basically nothing in terms of the interests of Trump and others in this information not coming out. And on the other hand, a really exigent, this is all we got, right, is what happened? What will the verdict of history be? That's precisely what they are trying to smother. Any fair-minded analysis of the deliberative process privilege would say, sorry, this now yields. The question is, how will it get to the 11th Circuit to actually review what is going to be a complete, phony baloney and skewed decision on her part? But this idea that it's a deliberative process is, yields exactly as it should. It's totally bogus because they're pretending there's big interests on one side. What would those interests be, by the way, for the Department of Justice? You can see Nauda and De Oliveira saying, well, I just assume all this terrible stuff that I've done not come out in my life. That would be that much. What is the Department of Justice suggesting is the reasons for the justice system and that represents all the people, that this should never see the light of day? It's completely Orwellian, right? But so there's going to be some problem practically defeating this. I'll just say, it may be this year by the 11th Circuit. It may be 10 years from now from another attorney general. We will one day see volume 2 of Jack Smith's account. We will one day have a very clear historical exposition that Trump was as guilty as sin, not just simply purloining the documents, but repeatedly obstructing them, but it could be a long time. And in between, the indefatigable campaign of Trump is to, I erase what was in front of everybody's eyes, both January 6th and this part where he really doesn't, as you say, have a leg to stand on. So the perniciousness of the Department of Justice, not only corrupting the justice system itself, but the very right of the democracy to know, it's nauseating.
Harry, there's links here also with the videos you and I have done on the Epstein Transparency Act, where we've been saying the problem is that who can enforce this? Usually the Department of Justice is, in theory, the good guys or the good gals doing the work, representing the justice. But where they're aligned with Ghislaine Maxwell, our system was not built on three players to a litigation. It's the prosecution and the defense, a plaintiff and a defendant. We don't have a word or something to describe what this other thing is. And so here, your point is, well, what happens when the DOJ and the criminal defendants are literally the same team, not just on this case, but on all of these cases where if you give Donald Trump some money or you give his PAC or you hire a Trump lawyer, the DOJ now becomes on your team and the federal judge takes its cue from what's being recommended by the executive branch and the prosecutor. But even in the other cases, Harry, where a federal judge is, where we have, Judge Cannon's egregiously corrupt, but think about the case with the former New York mayor, where the prosecution says we're no longer to pursue it. The judge can't be like, the judge can send a stern warning or write a nasty order or whatever it is, but the judge can't really, I'm the prosecutor now as the judge. I'm going to do this. And the same thing here, the 11th Circuit can't, on its own, doesn't have some independent power to say, we're observing what's taking place, not cool, so we're going to jump into you, Eileen Cannon. That's the problem. So someone has to make a motion, and what's the Trump regime going to argue? Same thing they argued with Epstein. No standing, you're not a party, it's a criminal act. Random people can't jump in and ask the 11th Circuit. So that's the problem, Harry, is what do you do when the whole system is now broken because you have a criminal regime?
It's exactly right. And there's actually is a name for this, that you teach your law students, a collusive lawsuit. But what that means, really they're on the same side. There's a way of thinking about it that it should just go away, but it doesn't matter because we would be left with the status quo. Collusive just means that there wouldn't be standing. But that's, forget about these legal highfalutin terms. We are exactly where you say we are. The good guys are the bad guys. The bad guys are the bad guys. And they're arrayed together against whom? The country. The country. Look, if somebody doesn't want to see the facts, they don't have to read volume 2 of the report. But how can you say that this episode that so roiled the country, even if you take the, bizarre counterfactual view that Trump was phony, how can you not say that the country deserves the facts of everything its government uncovered? It's untenable, but they don't ever, they don't have to say it. They just have to submit papers in front of Judge Cannon that says, oh yeah, we agree with the defendants here. Never let it see the light of day. This is broader than anti-criminal stuff, as the department is doing. It's broader than Bondi as the anti-DOJ. It is the government as the anti-democracy, trying to, it is as Orwellian as you get, just trying to rewrite and erase and smother the history of, what by any account and any political orientation has to be hugely important public understanding of what the hell the president of the United States did. It's just, and to do it, by the way, to on the one hand say, oh, this is deliberative process, and then on the other file the motion and take the official position of the Department of Justice. The whole thing was illegitimate, and basically to trash it and make it seem that all these details that we won't reveal to you, and if you looked at, you could just assess, are somehow themselves unfounded and inauthentic, which is the farthest thing from the truth, is just the height of, hypocrisy and corruption.
Right. You almost have to think about, in a future administration, does Congress need to pass laws that just completely reconceive of standing? And if you get captured by an authoritarian regime, can you empower an Article 3 to sua sponte intervene? And, we have to, our language and the rules of the game are incapable of handling this, because it was based on good faith and understandings, and the entire Constitution is imbued with implied covenant of good faith and fair dealing. And that doesn't work with Trump or future Trumps out there. And, you and I can spend hours devising what this can be or look like, but clearly our Constitution and our laws cannot handle a lawless DOJ. It doesn't work.
Mr. Meiselas, can I just say in closing, and with no pandering intended, that's a friggin' brilliant point that just really is so cross-cutting for this administration. We're at the point, the framers never thought they were infallible. They did the best they could. They understood that certain wickedness could, in fact, penetrate these parchment barriers. And that really is what we're living through week by week.
Everybody, make sure you subscribe to Harry Litman's YouTube. It's called Talking Feds. So after you finish watching this video and you subscribe here on our YouTube channel, subscribe to Harry Litman's. Search Talking Feds and subscribe to his Substack and subscribe to his podcast. Thanks, Harry.
Thank you, Ben.
Want to stay plugged in? Become a subscriber to our Substack at MeidasPlus.com. You'll get daily recaps from Ron Filipkowski, ad-free episodes of our podcast, and more exclusive content only available at MeidasPlus.com.